The Bombay High Court has directed the Maharashtra Anti-Corruption Bureau to not act on a special court's order seeking an FIR against former SEBI Chairperson Madhabi, Puri, Buch and 5 other officials in connection with a listing dating back to 1994. This still adheres the case tomorrow. Madhabi, Puri, Buch and SEBI whole-time member Ashwini Bhatia, along with the BSc MD, had moved the High Court challenging the FIR order issued by an anti-corruption branch court on Saturday. Ashwin Kumar joins us now. Ashwin, take us through the key contours of the plea challenging the lower court's FIR order.
Well, the order we came out over the weekend. The counsels for Madhabi, Puri, Buch, as well as the SEBI officials were quick on their feet. First thing in the morning, they moved the Bombay High Court. High Court has granted them relief. No FIR can be registered against them. The case will be taken up tomorrow. Now, we also got access to their petitions that they filed before the Bombay High Court, and some important points being brought across. Number one, the petitions argued before the Bombay High Court that this order sanctioning an FIR is manifestly erroneous and patently illegal. In fact, why? The petition then goes on to say that as far as the allegations are concerned, they pertain to violation of a SEBI circular of 1992, that's 33 years back. Also goes on to argue that the company in question, CAL's refinery, was listed way back in the year 1994, and that at the time, none of the officials who are facing these allegations were even in the picture. Further, the petitions also go on to argue that as far as the petitioner, the locus of the complainant is concerned, that complainant appears to have bought shares way back in 2009. And therefore, given that it comes 15 years after the listing of the company, he could not have possibly suffered any grievous losses. And also, the petition points out that he appears to be a habitual litigant, appears to be a habitual complainant, that he's been reprimanded on various occasions by multiple courts. Also, the petition points out that as far as a public functionary is concerned, for them to face any prosecution, there is a requirement under the Prevention of Corruption Act to secure a central government sanction. That was a glaring mistake that was made by the lower court, is what the petition argues, that was not flagged by the lower court. Also going on to finally say that no notice, no opportunity had been given to those facing questions, to those facing allegations, to come good, to make their position clear, to argue in their defense, and that without hearing them, an order had been passed, and that even in the past, SEBI has not been wary of taking regulatory action when required against companies such as CAL's refinery. So a whole host of allegations, questions being answered there. As a part of these petitions, the Bombay High Court, we understand, will take up this case first thing in the morning tomorrow.
All right. Thank you very much, Ashwin, for joining us with that important case update. Moving on, India and the European